Recording. All right. Thank you, everyone. Thank you again for having me out. I love coming out and giving these presentations to everyone. Tonight, we're covering estate planning, special needs trust, able accounts, and guardianships. There's a whole bunch that we are going to try to tackle tonight. And I want to give you a roadmap of where we're going to go tonight, right? First thing we're going to look at is why do we plan? And there's a lot of our children who, when they turn 18 and then 21, who are going to need supports and services either from local government or the federal government, either supports through the Division of Developmental Disabilities or receiving supplemental security income. And we're going to talk about those benefits that are out there. And that really drives the reason why we need to plan with a special needs trust, right? Everyone should have a plan in place because that's the responsible, smart thing to do. Not all of us do. But the reason why it's more important for us is so we don't jeopardize those benefits that we are going to put in place for our children. So we're going to look at that why first. And then I'm going to go through the different parts of the estate plan for you, right? We're going to break that down into what is made up of the estate plan, what documents we include, and how and why we need to draft them differently or slightly differently for individuals when we're caring for an individual with a disability. We're going to specifically look at special needs trusts, right? There's a lot of confusion about the different types of special needs trusts because there's two types that are out there. We're going to talk about them and educate you so you know the difference between both of those. I'm going to talk about able accounts, which is a very special type of account for an individual with a disability. It's a savings investment account. And the last thing that I'm going to cover is guardianship, right? Now, guardianship in and of itself could be an entire hour plus presentation, but we're just going to talk about the surface level of understanding what that standard is for guardianship and what we can do if guardianship is not appropriate, because it's not appropriate in all cases, how we can continue to support that individual in our life. So let's dive down. First thing is if we don't have an estate plan and mom and dad, and I'm going to use for tonight, just for the sake of simplicity, you'll hear me say mom and dad, and I'll talk about having multiple kids. There is a whole bunch of blended families. There's a bunch of different types of families, but for the sake of simplicity, I sometimes say mom and dad. Mom and dad, usually when one spouse passes away, all of their assets will pass to the other spouse. When the second spouse passes away, the assets without a plan in place will pass down to the children, right? And so, what that means is, first of all, if you have a minor child, you could have a minor child that inherits significant assets at a very young age, right? So, let's use the example of having, a modest home in Middlesex County. Maybe it's worth 300,000. Some are more, some are less. Just using easy numbers for tonight, and you have two children and you pass away, and each of your children now inherits an asset or half of an asset that's valued for each of them at $150,000. That's not counting bank accounts or vehicles or personal property or maybe retirement accounts or life insurance policies. So now at maybe the age of 15, they have $150,000 in assets. The problem for us is if we have a child that's receiving these government benefits, they need to make sure that they keep their assets under a certain threshold amount, which means they can't have assets more than $2,000, right? 2,000 at any given time. So here, if they've inherited $150,000, it's going to jeopardize their benefits. Means if they're in a day program, if they're receiving transportation through DDD, if they're on a housing, they're going to lose that in addition to losing that income that they have coming in. So it's important for us that we make sure that we plan so that way assets don't go to them directly. And this is where that special needs trust comes into place. We can set this up to where it doesn't go to them directly. They can still have the benefit of their inheritance, but without it jeopardizing their benefits. So let's take a look first at these government entitlements and benefits, so we understand what we're talking about. When your child, I'm going to back up a second, prior to your child turning 21, the school district is going to be responsible for providing education and including therapies like speech therapy, OT therapy, up until the age of 21, if that's needed, right? So if they're receiving special education and related services, they can stay beyond the age of 18 and continue there to prepare them to transition, whether it's to college, whether it's to the workforce, or whether it's to whatever that next step is going to be in life, right? But the idea is that the school district is in charge of that up until the age of 21. Well, if they're not going to college or in the workforce, are they going to be part of a day program? What activities are they going to do when they turn 21? So a lot of times, individuals will have services through the Division of Developmental Disabilities, and we're going to talk about how we get there. But the first thing we do when a child turns 18, we tell mom and dad to apply for supplemental security income for them. This will give them a monthly stipend prior to the age of 18. The government's going to look at mom and dad's income, right? So they're not going to look at, they're going to look at that, the child's not going to be qualified. Once they turn 18, they're not going to look at mom and dad's income. And so they'll have the ability to qualify for SSI. In order to be qualified, not only do they need to have the income below that certain amount, but they also need to be disabled, right? And then once they start receiving it, they have to continue to keep their income and assets below a certain amount. So if they have money coming in for food, clothing, and shelter, they should be spending it every month towards those, not squirreling it away, saving it. I know a lot of parents would think, hey, my child has this coming in, let me save it up. But it doesn't benefit them because then literally it would jeopardize their benefits. What's going to happen is when you apply for SSI in New Jersey, the application for Medicaid is done at the same time. It's one application. And Medicaid, it's the federal medical program for individuals that have income and assets below a certain threshold. Um, and it provides medical health care benefits. Now, not everybody necessarily needs the benefits. Your child may have benefits through you, right? So they might be on mom and dad's policy, but the Medicaid would then be a secondary policy for them. But what's very, very important, and that's why I put this little image there, is that Medicaid becomes the key to eligibility for other services. So when we talk about the DDD services, these are services you must be Medicaid eligible even to qualify, right? So that's where this is really important. Look, you might not need the medical, you might not need the extra income from SSI, because mom and dad might be well off, but in order to even be eligible for DDD services, they need to be Medicaid eligible. So that's the key to unlock these services. So DDD provides the services that somebody would be entitled to after the age of 21. And this can vary, much like you have an IEP for school, that you have a plan in place with your support coordinator for DDD, how you're going to spend that budget, right? So an individual based on their disability is assigned a tier, and that tier correlates to a budget. And how they spend that will vary from person to person, right? And it can cover things like their day program, transportation, housing. This is where you need to get on the list for a group home or supported living in an apartment. That would be covered here. Therapies, there might be training involved, other activities that could all be covered by an individual's budget through DDD. Now, it's very important. I just want to mention that DDD provides services for individuals that are developmentally or intellectually disabled. So they need to meet a very specific clinical definition, and they also need to be Medicaid eligible. So that's very, very important. So we go through all of this. So we set up our child to have these benefits for when they are, reaching the age of 21. We want to make sure that we don't jeopardize that if something were to happen to us. So we're going to talk more now about the estate planning with a special needs trust in mind, and how that, prepares us for our child, making sure we don't jeopardize that. So the first document I'm going to cover is a will. Right? We hear about this all the time. People have their will, their last will. There's a lot of myths going on about wills. People think you have a formal reading of a will when somebody dies. We don't do that anymore. That's mostly in the movies. But a will does very specific things, and it's important for us to understand the job that the will does, right? It controls what happens to your assets, right? What's going to happen to that house? What's going to happen to your bank accounts? But what's important to know is the will does not control everything. Right? If you have a life insurance policy with a beneficiary designation, or you have a retirement account with a beneficiary designation, the instructions are that beneficiary designation form. not the will. So that's going to pass to those individuals that you designate as the beneficiary, right? The will is going to control everything else that doesn't have a beneficiary designation on it that you own. So it could be your house, could be your car. And your will is going to say, number one, what's going to happen to them, who they're going to go to. Number two, who is going to handle your final affairs, right? So who's going to close out your bank accounts, do a final tax return, clean out your house? Who is going to take care of all of those things for you, right? And um, if you have minor children, we want to make sure that we say in our will who you want to care for your child if you are no longer alive, right? And this is a very specific distinction because we're going to talk about other documents that might allow somebody to step in and care for your child for you if you're still alive. But here your will says if you've passed away, who you want to care for them. Now, if you have an adult disabled child who's under guardianship or may need a guardianship in the future, we want to also put in your will who you would want to care for them if you are not here, right? So that's very, very important that we would put that in your will. So one of the key things, the way we set up the will, is that instead of leaving it, let's say you have two kids, instead of leaving it to child A and child B, we're going to leave it, let's say child A has special needs. We're going to leave it to child A. We're going to leave it to their special needs trust, not to them directly. So because it never goes to them directly, it goes into the trust. It doesn't jeopardize their benefits, right? Because it stands outside of them. It's another entity unto itself. So the trust, and talking about a trust, it's important for us to understand that there are three parts to a trust, right? A trust is an agreement between you and someone else that says, hi, I'm going to hold this property, whatever the property is, for another individual, that individual being your child, right? In our scenario. So a trust always needs three, it's like a three-legged stool. It always needs three parts. It needs someone to set it up. That's the grantor, usually mom and dad. It needs someone to be the beneficiary, which will be your child. They're going to benefit from the trust itself. And the third part that's needed is who's going to be the trustee. That's the captain of the ship, right? The trust always needs to have a captain of the ship, right? If it doesn't, then we need, you have to go to the court, petition that. But we want to make sure we always name a trustee to be in charge of this. So those are the people that are involved in this trust. And there's many different types, right? We talk a lot about special needs trust or supplemental needs trust, but there could be trusts for families that have blended families, trusts to collect life insurance money, trusts to help save taxes, a variety of different reasons why we create trusts. And the way we create it is with a legal document, right? Most of the time, the special needs trusts are between 30 and 80 pages, depending on the family and some of the language we're putting in there. But that special needs trust details out the purpose that it's for that beneficiary. And in our case, we want to make sure that we have detailed language in it saying that it's not going to jeopardize their benefits and what it can be used for. And of course, if mom and dad aren't here, we want to make sure that if your child is used to doing certain social activities or religious activities, that your trustee knows that and can continue doing that. And so when we're talking about a special needs trust, a special needs trust or a supplemental needs trust is a very specific type of trust to benefit an individual with disability. So there are two types of these trusts. One is called a first party special needs trust. And this is when an individual, meaning the child, actually has that money already, right? And we're going to talk about what makes this one different than a third party special needs trust. So that first party special needs trust is a scenario that I talked about in the beginning. Mom and dad pass away and they don't have a plan in place. And now your child has $150,000 of an asset. What we need to do is we need to go to the court. We need to petition the court and ask their permission to set up a first party special needs trust. Well, it's expensive, it's costly, it's time consuming. And in the meantime, we're fighting with every agency out there not to cancel their benefits, or if they've been canceled, what we can do in the interim until we can get the court to approve this special needs trust. So that first party special needs trust, because it's court approved, one of the drawbacks is that when your son or daughter passes away, any money that's in that trust goes to Medicaid. It goes back to the government for the services that it provided your child while your child was alive. So that's a problem, not for some people, because they're saying, hey, listen, I worked hard for this money. I want it to benefit my child. But if my child passes away, I want it to go to my other children or my grandchildren or my nieces and my nephews. Well, if that's the case, we want to make sure we plan and we create what's called a third party special needs trust. Why is it a third party? Because it's between you, not between setting this up. You're the third party to the transaction, where your child is the first party to that transaction. And one of the things that you get to decide in the third party special needs trust is what happens to the funds after your child passes away, where it goes. Um, so the other key pieces are, and I'm going to talk about just funding. Funding them is different um, because it comes from different sources, right? So the first one I talked about, you'll see on that bullet list, the unexpected inheritance. That's the example that I used in the beginning. Mom and dad passed away without a will. Now they have it. Sometimes a child may be in a car accident, there might be medical malpractice, and they may receive a settlement, right? And so they may come into a significant amount of assets, and we couldn't predict that or change that or do anything about it. And so we have no choice but to set up a first party special needs trust for those. Sometimes they have their own assets. Oftentimes, grandma, grandpa, even family members may buy child savings bonds and they will accumulate them over their lifetime. And then when we go to apply for benefits at 18, we realize the child has $15,000, $30,000 worth of bonds and assets. Sometimes they have a college savings plan. All of those we would have to, because they are already part of that individual's assets, they own it, that's their property, we would have to fund a first party special needs trust. The third party special needs trust gets funded slightly differently, right? This is from mom and dad's estate plan. And if mom and dad set up a special needs trust, I tell people if no reason to reinvent the wheel, right? If grandma and grandpa want to leave something to their grandkids, have them direct the money to the special needs trust that you've already set up for your child, right? As long as they can agree, whoever's going to receive it afterwards, they're okay with whatever your plan is or whoever the trustees are. As long as everybody's on board with that, then no problem. Grandma and grandpa can direct it there, because why have multiple trusts if it's not needed? Um, Oftentimes, you can fund a third party special needs trust with a life insurance policy, with an annuity account. Sometimes people will leave it as the beneficiary for a retirement account, various different ways that we can do that. Um, and who handles the trust? Like when we talked about it, it needs a trustee. It always needs to have that captain steering that ship. And that could be an individual, it could be a corporation, like banks have trust departments that could serve as a trustee. Sometimes we'll have a co-trustee, we'll have two trustees on an account. There's nonprofits that may serve as a trustee, or a combination of these. We want somebody that has what I call the soft skills and the hard skills. We want somebody who knows your child, who knows what they like, what they dislike. If they get upset, what makes them calm down, what the activities they like to do. And then we also need somebody with good record keeping, good financial sense, who's going to make sure that the money is handled well on a day-to-day basis. Right, so we need a little bit of both, and sometimes you might not get that in one individual. You might have somebody in your family who's really good with the numbers, and somebody who knows your child very, very well. Right, in that case, you might want to think about co-trustees. So the trustee has to do things like invest the money, approve the spending, and there'll be an annual accounting once the trust is funded, and they'll do tax returns. Um, so the first party special needs trust, that's the accidental trust, the one that has the Medicaid payback provision. Um, you must do an annual accounting to Medicaid, right? So every single year you need to send them how you spent the money, what's come in, what's gone out, what you spent it on, things you did, and they will nitpick on every little thing that comes out of the trust. Number two, you need to give them 45-day notice for any expenses over $5,000 or any expenses that might significantly deplete the trust, right? So there's this level of oversight that you have with that first party special needs trust. Sometimes we can't avoid setting them up. It is what it is. But if we can avoid setting it up, if we can plan, then let's go ahead and plan and avoid that oversight. So what can this money be used for in the trust, right? So your child at this point, when this trust is set up, should be set up earlier than that, because we want to make sure that we set it up at a young age. But at some point, they're going to be receiving those government benefits, right? And so they should be receiving that SSI, which would cover the food, clothing, and towards their shelter. So the trust should supplement that, right? That's why you sometimes hear me say supplemental needs trust. It should supplement the benefits they are already receiving, not supplant it. It shouldn't take its place, right? And so these are things like vacations. If your child's used to getting a vacation annually, um, furniture, household goods, a new mattress, maybe an iPad, all things that might not be covered or there might not be money for. Um, and that's what that is meant to cover, right? So it's meant to supplement, make their life comfortable with all of the things that they would normally expect and mom and dad would be providing for them. So that's where I'm going to finish up here with special needs trust. And I'm going to move into the other documents that we put together as part of the estate plan. But before I do, I just want to mention when I set up a special needs trust, I usually put mom and dad as the initial trustees. It might not be funded while mom and dad are alive, but in some events, if grandma and grandpa want to direct money there, they can certainly do so, right? And there might be strategy reasons why mom and dad may fund it while they're still alive, but of course, if they're still alive, they should be the trustees. And then afterwards, we're always going to think about who's going to be our backup, who's going to be that backup trustee. So we have that plan. The other document we use as part of an estate plan is a power of attorney document, right? So this is used to delegate your legal and financial decisions to another person, right? Um, there's different types, whether it's durable, meaning that it goes in place immediately, regardless of your health condition, and another type of power of attorney that could be springing, that only goes into effect if you are incapacitated. That becomes a little bit more complicated to use in practice, and that's why I tend to lean more towards the durable power of attorney, but there's pros and cons. You could also do a limited power of attorney where it's only limited to a certain time frame. What's important is if you are a guardian for another individual, you would want to name in here if you need to ever temporarily have somebody step in as the guardian, who that person would be, right? So we want to make sure that that information is put in your documents as part of your estate plan. Um, but it's always good to have somebody named to make those financial and legal decisions for you if you can't. Medical directives, living will. Um, Usually what I do when I'm preparing the documents is I do a series of different documents. The first one I do is a healthcare proxy, sometimes a healthcare power of attorney. This is where somebody can make healthcare decisions for you if you cannot. Um, if you are a guardian for somebody else and you can't make medical decisions for yourself, you certainly can't make them for someone else. So you'll definitely want to fold them into your documents. Um, the other thing is a living will. This is your end of life decisions, right? If something should happen to you, your condition is terminal. Do you want to have further medical treatment or do you want them to stop at that point? And the other one we do is a HIPAA release because it's important that the person have access to your medical information if they're making a decision for you. We want that to be an informed decision. So this is the package of documents that we put together as part of the estate plan to make sure that you're taking care of yourself and then also taking care of your children. And I talk about, this being a child with a disability. This is also super important to have it, even if you have minor children, right? So if you have minor children, I'm usually also including a document called a minor power of attorney, where you could delegate someone to, pick them up from school, take them to the doctors if they're sick. I call it like the emergency contact list, but that's a very specific minor power of attorney document we can do here in New Jersey for to handle those items. So I mentioned earlier assets that are outside of probate, right? Those life insurance policies, your retirement accounts. We care about these because if we don't make sure that they are directed properly, they could jeopardize your child's benefits. So, example, you might have your spouse as the primary beneficiary and your children as secondary. Well, if you're the second spouse to pass away, we could put a beautiful estate plan in place with a special needs trust, but if you never update your retirement account, your beneficiaries, that could end up paying out directly to that child with disability, and they could end up jeopardizing their benefits. So what we do is when we do the estate planning, we talk about what else do you have out there, what other assets do you have, and make sure that we put them directed to the special needs trust, right? That we make sure that it's going there, not going directly to your child. So these are I call like a little board of other types of planning parts of our plan that we put together. I tell folks, Listen, I know it's an uncomfortable topic to talk about, funeral and burial instructions to have plans in place. But it is very, very important because if you have children that are making these decisions for you and they're young, they're teenagers, they may not know what you want and they may be grieving, right? So, to the extent we can make these decisions and we take that grief away from them, right? So they can focus on what's happening. They don't have to worry about these. It makes it easier for them. Number two, we also make sure that our wishes are carried out, right? We're not guessing that something's going to happen. Um, I mentioned here a letter of personal property. If you have specific family heirlooms, maybe you have a family ring or you might have a painting that you want to go to an individual, you don't have to put that in your will because it's personal property. And we can specifically list that on this memorandum that stays with your will. And you can update that because a lot of times folks will want to change, if they have a lot of grandkids, they might change, oh, I want this grandchild to get this. They can just keep updating that memorandum without changing their will. uh, Care instructions for a child. Sometimes this is called a memorandum of intent. What I do is you have, and I know you do because you're taking care of probably a child that requires lots of doctor's appointments and an IEP, meeting with different specialists. Maybe they have different therapies going on. Um, you have this information most of the time in our heads. Maybe some of you are organized and you have a list on the computer, but I tell folks and I give them instructions for prompts for what to write out. If somebody had to step in for you, um, what would they need to know about your child, right? The for all from the medications that they take to the doctors that they see to what are their likes and their dislikes, right? So that's something that we want to make sure we have, and that's something that we want to make sure that we update periodically as your child grows. Um, Also, we want to talk about if you are a guardian, let's say one spouse passes away, I always recommend that we add that backup guardian on while you're still alive. It gives you that opportunity to start folding them in to the decision making process, to let them know what's going on, introduce them to people, and let them start taking the reins of control. So there could be a smooth transfer when you're no longer here. A lot of times people are like, well, I don't want to add a co-guardian on now because I don't want to go back to court. That's an added cost. The reality is the cost is either going to be while you're alive or when you pass away, right? The cost is there to get that backup guardian on. We still need to go to court. That's the only way that a person has the power to act as the guardian is by a court. And if you wait till you pass away, what ends up happening is that you pass away. First thing is we cannot probate a will for 10 days after a person has passed away, right? So then you probate the will, assuming in a perfect world that we're able to get all the documents, meaning we've ordered death certificates, they've come in, and we found the original will. We can get all of that to the surrogate on day 10. Might be about, could either be that day, or if you're doing it by mail, because that's what they started doing during COVID, could be another week until you're actually appointed as the executor. But then a petition needs to be filed in court for that guardianship, and that could be 60 days until that hearing is done. So you could be going 2 or 3 months where there's not a guardian for your child, right? So it's really important that let's say one spouse passes away, you're starting to age. Let's be smart about it and get that co-guardian on while we can. The other thing is, lists of accounts, passwords, access to things online. You pass away, even if you're sick, somebody needs to step in for you. You know, don't make it difficult for them. How can they get in? Where can they find that information? How can they access it? Also, if you have a safe deposit box, make sure your family knows where it's at. And what I do for my clients is we put together their estate plan in a binder. And in that binder, there's tabs with everything. I put tabs for some of this additional information. And then I put everything on a flash drive. And I tell them anything else you have that's relevant and important, you put this in that binder. So that way your family member can just go to the shelf, find it, pull it off the shelf, and they know they have everything right at their fingertips to help out. So, just going to mention this super briefly. Here, you want to make sure that if you have an estate plan in place, you update it anytime you have a major life event. I tell clients to look at it annually. I send them a letter just to remind them to do so. And about every 2 to 3 years, you should be sitting back down with an attorney because laws do change, things evolve over time. So make sure if you're going to go through the trouble of putting an estate plan in place, then make sure let's keep it current so that way when it's needed, it is as current as possible. So, moving on to New Jersey ABLE accounts, right? And this is a very, very specific type of savings account. It's the sister to the college savings, right? It's under that same umbrella for the IRS 529, and it is for individuals with a disability, right? The disability needed to start before the age of 26. And as long as they are receiving SSI or SSDI, or doctor certifies that they have a disability that started before the age of 26, they are able to open up this account. This can be funded by mom, dad, the individual themselves. Anybody can fund this account. It's a it's an investment account, so it does earn interest on the account, and that interest is earned tax free, much like a college savings account. You can put, or your son or daughter can put up to $17,000 in this account, right? So this is a nice little tool to have for a couple different reasons. Um, if they are working, you see that other number below, the 13,590, they can contribute an additional 13,000 beyond the 17 into that account. Now, one of the benefits, the really big benefit of a New Jersey Able account is that it does not count towards that $2,000 spending asset limit, right? So that's beautiful, right? It doesn't count towards that. This is a way for an individual to save money. Now, once it reaches $100,000 in this account, it could jeopardize, it will jeopardize their SSI if they're receiving that, right? So definitely stay below that amount. Now, sounds too good to be true. That's because it usually is. Um, there is a drawback to a New Jersey Able account. The biggest downside is that when that individual passes away, money that's left in this account will be paid back to Medicaid. But hear me out before you discard this as an option. This is a very, very, very useful tool to have for a couple of reasons. Number one, say set up the account, put a small amount of money in it, 50, 100 bucks, have it just sitting there as an investment account, right? The reason why is, who would have thought in any scenario that COVID would have happened, that we would have been shut down, and that we would have received the stimulus checks that we did. Now, individuals that were, let's say they were early 20s, they had disability, they were in a day programs were closed, activities were closed, everything was shut down. Receiving SSI, they were receiving about 750 to 900 every single month. There was nowhere for them to spend this money. Everything was closed. And then on top of that, they received a $1,200 stimulus check from the government, right? So that alone, plus whatever was in their account, now they're over the $2,000 asset limits. I had clients calling me left and right. What can I do? Their benefits are going to be jeopardized. I got a letter from the Board of Social Services. What do I do? What do I do? What do I do? Well, what we did was we put money into an ABLE account. Why? Because it didn't jeopardize their benefits. They still had access to that money. They still could do that, and it didn't count towards that $2,000 limit, right? So that was a blessing in disguise. In order to have that set up for them, ready to go, they just transferred the money there. In some cases, they would have had to find a way to spend it down. We were telling folks buy new furniture if that was needed. Sometimes you could purchase furniture and it was delayed for months because everything was just at a standstill. So it was a very, very useful tool in that case. Also, they have that accidental inheritance that happens. If it's under that 17,000, let's say grandma leaves them $10,000, we can put it right into a New Jersey ABLE account. And as long as they receive that money, let's say on January 2nd, as long as that money is in out of their bank account and into the New Jersey ABLE account by the end of the month, it's not going to count when they check the accounts at the beginning of the month for SSI, right? So we want to make sure that if they do receive money in accidental inheritance, we can move that over very quickly into an account like this. So money that's in an ABLE account can be used on what we call qualified disability expense, right? So this is very, very broad, and it includes housing, right? Now, housing becomes its own very, very detailed concept that we can talk about. I guess a trust can own a house, but the trust in some other circumstances shouldn't be paying for housing expenses. And so it becomes very nuanced as to what's happening. But you can pay for housing expenses out of an ABLE account. And so what we do is we will sometimes set up an ABLE account. And if somebody needs money from a trust for housing expenses and we can't spend it out of the trust, but we can spend that type of expense out of this ABLE account, the beginning of the year, we move that $17,000 over. And throughout the year, they draw upon it for that housing expense that they have. right? So it's a way to kind of use the two things together in order to accomplish a goal. You can connect a checking debit card to the ABLE account if some folks want to do that. It does make it easier to spend the money that is put in there, right? So right now they don't really have a whole lot of record keeping requirements, but if something is spent on something that's not a qualified disability expense, technically it will have tax implications because the money earned in this ABLE account was any interest was earned tax free. Um, but outside of that, I tell folks make sure that we keep really good records. Right now, New Jersey ABLE is not requiring us to do any reporting on an annual basis, but we want to make sure that we have all of our records there just in case anything is questioned. So moving on from the ABLE account, sort of the assets, to the other piece of guardianship. I'm going to cover this topic quickly for us. Um, Not every individual with a disability will need a guardianship. And it's important to understand what that legal standard is as to when a guardianship is needed and how guardianship is divided. So the legal term is that somebody can't, or phrase is that they're unable to govern and manage his or her own affairs, right? And what that's going to look like is that they can't give informed consent because they can't weigh those legal and medical and financial choices, right? And so that would mean, if you gave them a contract to sign for an apartment when they turned 18, they wouldn't understand that if they didn't pay their rent, that they could end up being evicted, right? They may not be able to understand the risks and benefits of taking medication or a medical procedure. In the financial realm, maybe they can add and subtract, but they can't use that in any meaningful way, right? They can't use that in order to budget money or go food shopping. Um, Other things we look at is, are they aware of safety precautions, right? What sort of assistance do they need with their activities of daily living? Can they go to the bathrooms by themselves? Can they get themselves dressed? Can they pick out seasonally appropriate clothing? So we look at all of these to see if an individual is able to manage and govern his or her own affairs. If the answer is no, then they need a guardian, right? If they can't manage and govern their affairs, that means they cannot give it informed consent. And a lot of times folks will be like, yes, I understand my child doesn't, know what's going on, but if I put a paper in front of them, they'll sign it. And I can get them to sign a power of attorney or all these other papers. No, just because you can get them to form a signature does not mean that they've given informed consent and that document is technically void. So if they can't manage and govern their affairs, we need to go the route of guardianship. Guardianship is also divided up differently. And then I'm going to talk about alternatives to guardianship because some cases guardianship's not appropriate, right? And we absolutely want to put in place other documents to support that individual. But guardianship is divided up into two ways: guardian of the person and guardian of their property, right? So, guardian of the person, this is about where they live, social programs they're involved in, their well being, doctor's visits. Guardian of the property is literally their property, their money, those assets. Right. And so if a person, even though they're under guardianship, if they have a preference to the extent that can be honored, that you must honor that, right? So that's hard when we're mom and dad because we're used to making decisions for our child. Once they turn 18, even though they might be under guardianship, we still need to try to honor their decisions to the best that we can. The other way guardianship is divided up, and this is important to know, is there's what's called plenary guardianship and the limited guardianship. Plenary guardianship means they're completely incapacitated in all areas, right? So this means the financial, the medical, the legal decision making, over their education. So the guardian will have complete authority over those and the ability to exercise all of those delegable legal rights, right? So all the rights that that person has with those decision making. Uh, Now, a limited guardianship is a guardianship in just some of those areas. And sometimes we will see that an individual might be able to make medical decisions, but just can't do the financial piece because of their disability, right? A limited guardianship in just that area is going to be more appropriate, right? The court system in New Jersey is designed to take away as little as possible, right? So we don't need to take away all of those rights. The court will not take away those rights, only what's absolutely necessary. Now, if guardianship is not necessary, these are some alternatives to how we can continue to support that individual, right? So, first of all, like we call it surrogate decision makers. The law has some defaults set up in place, right? If you're in an emergency, they're going to notify next of kin. Um, that could be mom and dad, that could be their brother and sister. It's going to be mom and dad under the hierarchy, but let's say mom and dad aren't here, it might be the brother and sister. Um, but that's the default. Um, but not all scenarios have that set up, right? So there's not all scenarios will say, hey, I can notify the next of kin or I have authority. The medical world, police and firefighters, they do, but not, not maybe, a landlord. So that doesn't apply to all scenarios. So we need to think about other documents that we can put in place in order to continue helping and supporting that individual, right? We could do a power of attorney, right? As long as they have capacity and they understand what they're signing, we can have them execute a power of attorney to allow mom and dad to continue helping with legal decision making and financial decision making. We can do those medical directives and that healthcare proxy where they name mom and dad to help out with those medical decisions. Um, and one of the things is like if you don't have something in place, like a lot of times family will come to me and their child might be in their 30s and they're like, well, I know they need a guardian, but like none of the doctors have ever kicked me out of the room. And that, if your child goes along with it, fine. But you're going to get to the point where one doctor is going to say, no, I'm sorry, you cannot be in here. Especially during COVID, we had this happen a lot where if you weren't a guardian, you were not permitted in there because the only person that was permitted was one parent or one guardian with the child. And if they were 18, they were on their own. And that's very scary if they're not used to being on their own for those decisions, and they might not be able to make a decision. And so just because you were always able to do it before does not mean that you will always be able to continue to do it and that you won't run into problems in the future. So having that healthcare proxy in place does help out a lot. Educational proxy. So if sometimes folks will, be going to community college or a four-year university, and we'll want to make sure that we sign, a healthcare sort of power of attorney that mom and dad can continue to be involved in that decision making. Um, Little bit different when we're in the college world as to what universities and colleges will communicate with the parents, even though children have a disability. But the important part is that we can assign these so where that they can communicate with mom and dad. I put out down here a will. Why? Because we want to make sure that even though they might not have a whole lot of assets, because we are we're talking about individuals that are going to have to stay under that $2,000 mark for in order to continue their benefits. They're still going to need somebody to close out their bank accounts and to do a final tax return if necessary, any other final affairs, make decisions about their funeral and burial. And if they have the ability to make decisions, I say then let's go ahead and make sure that they're making decisions in all areas of their life. If you know guardianship's not appropriate, and even when it is, social security requires a representative payee, right? So um, you can be the representative payee and be that person that collects that social security money for them on their behalf and pays for their expenses every month and files the reporting that's required for social security. Now, New Jersey Able accounts, instead of calling it a representative payee, they called it an authorized individual. Same concept. It's the person that can help out and help manage that account for them, right? So these are the alternatives to guardianship. Some or all of these may be appropriate. They may not be appropriate. That's really going to depend on the individual's circumstances in their life and what they want in place based on what their needs are. So I know I've covered a whole lot of information up to this point. And so what I'm going to do really quickly is I'm going to stop recording here and I'm going to open it up for any